Judgment in the appeal, Société Coopérative and the Competition and Markets Authority.
Lord Sumption will explain the judgment of the court.
This appeal is about competition in the cross-channel passenger market. It raises issues of some delicacy about the impact of UK competition policy on the attempt by the authorities in France to contain the social consequences of a high-profile bankruptcy. Seafrance SA was a subsidiary of the French National Rail Service SNCF. It used to operate a cross-channel ferry service with 3 passenger ships and 1 freighter. After some years in which its operations had been dogged by overmanning and poor labour relations, the French court made a provisional order for its liquidation, and its operations ceased in November 2011. The ships were placed in hot layup, which meant that they were kept ready to resume operations at short notice in case a buyer should be found for the business. For a time, the workforce was kept on for the same reason. But in January 2012, the French court definitively put Seafrance into liquidation, as a result of which it was obliged to dismiss the workforce within 15 days, except for those members of the ship's crews who were kept on in order to maintain the ships. In order to encourage a buyer to take over the business, a fund was created, financed by SNCF, from which payments would be made to a buyer for each former employee of Seafrance that the buyer took on. The amount of the payment was graded according to what the buyer acquired. The highest level of payment would be made to a buyer who employed the former crew members on the same ships in the same service. In July 2012, Group Eurotunnel, the French holding company of the company operating the Channel Tunnel, bought the entire assets and business of Seafrance and took on most of its former employers in conjunction with a company called Société Coopérative de Production Seafrance, which was essentially a workers' cooperative formed in order to secure the jobs of Seafrance's former workforce. In the following month, the ferry service resumed under its new ownership with the same passenger ships and most of the same crews. However, shortly afterwards, the Office of Fair Trading referred the transaction to the Competition Commission on the ground that it amounted to a merger which could be expected to reduce competition on cross-channel routes. The Competition Commission and its successor, the Competition and Markets Authority, produced 2 reports in June 2013 and September 2014, in which they concluded that it was a merger and did have adverse effects on competition. They ordered Eurotunnel to cease operating any cross-channel ferry service to Dover using the ships acquired from Seafrance for the next 10 years. That order was upheld by the Competition Appeal Tribunal, but was reversed by the Court of Appeal. The Supreme Court unanimously allows the appeal and restores the decision of the Competition and Markets Authority and the Competition Appeal Tribunal for reasons set out in a judgment which I have prepared. Mergers affecting the United Kingdom are regulated under Part 3 of the Enterprise Act 2002. The purpose of merger control is to prevent undue concentrations of market power which can be expected to lead to significant reductions in competition. The issue on which the present appeal turns was whether Eurotunnel's acquisition of the business and assets of Seafrance in July 2012 amounted to a merger of their 2 enterprises. Only if it did was the Competition and Markets Authority entitled to direct Eurotunnel to abandon the service. This issue arises because UK competition law distinguishes between the acquisition of a business and the acquisition of an enterprise and the acquisition of what are sometimes called bare assets. If Eurotunnel, after August 2012, were operating the same enterprise which Seafrance had previously operated, then there was a merger. But if all that Eurotunnel really acquired was a collection of assets which simply happened previously to have been owned by the defunct enterprise of Seafrance, which they then used to create a new enterprise, then there was no merger, and the Competition and Markets Authority had no right to intervene. The authority's view was that the mere fact that the business of Seafrance consisted essentially of ships and employees, plus to some extent the old company's brands and goodwill, and that it had gone out of business and ceased to operate its affairs in January 2012, was not conclusive. The argument centred on whether Eurotunnel could be said still to have a business with which whether Seafrance could be said still to have a business with which Eurotunnel could merge in July 2012, given that the company had gone into liquidation 6 months before and had dismissed most of its workforce. The authority considered that the fact that Seafrance was no longer carrying on its business during that 6 months did not mean that the business had ceased to exist. The question in their view was one of economic continuity. If at the time when Eurotunnel acquired them, the various assets were worth more to Eurotunnel because they had previously been employed in their business by Seafrance, then Seafrance as business should be regarded as continuing, albeit temporarily dormant. After a careful analysis of the economic value of the assets, the authority concluded that this test was satisfied. They were particularly influenced by the SNCF-financed fund, which had been deliberately designed to enable the various elements of the business, including the ships and the workforce, to be kept together as an economic whole and sold to a buyer. What Eurotunnel acquired therefore brought them most of the advantages of a going concern, even though its operations had ceased. This analysis was endorsed by the Competition Appeal Tribunal. The Court of Appeal, by comparison, took a much more formal view. They thought that since the employees were critical to the survival of the enterprise, and since they had not been transferred directly or en bloc from Seafrance to Eurotunnel, but had been dismissed, that was an end of Seafrance's enterprise. All that Eurotunnel acquired, therefore, in the Court of Appeal's view, was a bundle of assets associated with a business that had ceased to exist 6 months before. In the view of this court, the approach of the Competition and Markets Authority was correct. The question was not whether the employees' connection with Seafrance had been severed, it was whether the employees had severed their connection with a business that was still capable of being acquired and operated by someone else. Economically, what happened was no different to the position that would have obtained if, instead of dismissing the workforce, Seafrance had kept them on the payroll and sent them on gardening leave until a buyer was found. Legally, of course, these two situations are very different. But this is a question of economic substance, and the economic substance was the same. In those circumstances, the Supreme Court concludes that what Eurotunnel acquired in July 2012 was more than a bundle of different assets with which to build a new enterprise. What they acquired was an existing enterprise which had previously been conducted by Seafrance. The authority therefore rightly treated it as a merger and had jurisdiction to intervene in order to regulate its effects.